the chairman of the full committee for his combined opening statement and such questions as he may have.
I don't know if I have that. Thank you, Mr. Chairman. Judge St. Eve, so you're requesting a 9% increase, is that accurate?
That's accurate.
How many, what's the federal district, is it 677? How many federal district judges?
It is around that.
Around that number? Yes. What's the average, what's the staff size for, what's a budget for your typical federal district judge, and what's the staff size that they would have working for them and for the court?
So for a typical district court judge, they have 3 staff members. Judges can make a determination if they want 3 law clerks or 2 law clerks and a judicial assistant. In addition, the district court judges have a court reporter and a courtroom deputy, although those positions—
What's the total number then of all those?
That's 5, but in some districts, the courtroom deputy and the court reporter are shared. So one district court judge does not have his or her own courtroom deputy or court reporter. That varies by district.
And each judge has, you said, 2 or 3 clerks?
Correct.
Okay. Of the 9% increase, how much of that's going for security?
Hey everyone, welcome back to the channel. If you're new here, I'm American Interest, your independent political analyst. My goal is to cut through the noise, the drama, and the spin to give you fair, honest, and fact-based analysis on the most pressing political issues shaping America. Today, we're reacting to a particularly heated congressional hearing involving New York Governor Kathy Hochul. The focal point of the exchange? A criminal case involving a man named Jesus Romero Hernandez, a repeat deportee with a violent history, and whether the state of New York, or more specifically one of its counties, failed to cooperate with federal immigration enforcement. Let's walk through what happened. Then I'll break down what it tells us about the state-local-federal relationship, immigration enforcement, and political posturing in our institutions.
The 9% increase, our security account is asking for $892 million.
And what percentage of that is that of the overall 9%?
A little under 10% of our budget, the full budget. So $894 million of the $9.4 billion is for our judicial security account.
Understand, but you're asking for an additional you're asking for a 9% increase. Of that increase, what percentage of that 9% are you devoting to security and going forward?
I think our increase for the judicial security account is a 19% increase over what it is now. That's comparing it from fiscal year 25 to what we're requesting.
Or maybe I'm okay. You're overall. What's the overall dollar amount you're asking for compared to where you're at now and what you're going to have for the next year? In
just judicial security or overall?
Overall.
So the overall amount that we are asking for is $9.4 billion for fiscal year 20.
And that's an $800 million increase over last year?
That is about a 9% increase over last year.
And what's that dollar amount?
The dollar amount, I have to.
My understanding is you're asking for $800 million increase. Is that accurate? $800 million.
I think that is accurate.
Okay, and of that $800 million, how many of what's the dollar amount going for security?
The total dollar amount going to security is $892 million, and that is about an increase of $142 million over 25.
Okay, so the
out of the, I'm sorry.
Go ahead, say it again. Go ahead.
Out of our overall increase, $142 million is in the court security account.
Okay, so that means $658 million is for other things.
Yes.
And where's all that going?
Defender services, we're asking for $1.8 billion. The S&E, or salaries and expenses account, we're asking for $6.9 billion, and that salaries and expenses goes to cover people and buildings primarily, and IT.
But now you're giving me the total number. I'm of the $800 million increase, you said $142 million is going for security. That leaves $658 million new dollars. Where's that money going, the new dollars?
So the additional increase is $800 million over from the prior year. I don't have this broken down into percentages.
Well, just give me the dollar amount.
So the dollar amount for defender services, the additional amount we're asking for is $315,000 roughly We're asking for a little less in fees and jurors. We're asking for the $141,000 in court security. $100 million in court security.
Okay, okay. Well, I mean, again, I think members are comfortable. I've said this all along. We're comfortable with making sure there's security. We're not so comfortable giving increases in everything else. I think that's where members are, certainly the folks I represent back home. I think that's where they see it. That's our concern, particularly with some of the decisions we've seen. So with that, I would be happy to yield my remaining 12 seconds to the chairman.
I'll take all 12 seconds to place in the record, and it's a video, so I'll just extrapolate the statement. On the 1st of April 2025, the speaker's comments that were earlier referred to verbatim are, "We are not defunding the courts. We're not doing anything other than limiting in this legislation the ability of a judge to issue a nationwide injunction." I want to make it clear the Speaker of the House very, very clearly had no intention of saying that there was going to be any limiting of judges on an individual basis, but rather the nationwide injunctions, which was a bill that was passed out of the House. And with that, I go to the gentlelady from California.
This hearing centers on a case that is, frankly, alarming. Jesus Romero Hernandez, a Mexican national with 7 prior deportations, was back in the U.S., residing in New York. According to the testimony and questioning, Hernandez allegedly assaulted a resident with a machete, choked a police officer, attacked a corrections officer while in custody. ICE, U.S. Immigration and Customs Enforcement, issued a detainer requesting that local authorities, Tompkins County Jail, hold him until federal agents could take custody. And here's where the political firestorm begins. Tompkins County declined to hold Hernandez, even after ICE confirmed his identity and provided a final removal order. ICE reportedly arrived 1 hour and 18 minutes after being notified, only to find Hernandez had already been released. The senator questioning Governor Hochul used this incident to highlight what he considers the dangers of sanctuary policies, local or state laws that limit cooperation with federal immigration enforcement. Governor Hochul's response was consistent with how many governors, Republican or Democrat, framed the issue. She made a clear distinction between state-level cooperation and local autonomy. She emphasized that the state of New York does cooperate with ICE in criminal cases. In fact, she pointed out that state prisons have handed over 1,300 individuals to ICE. However, she stressed that Tompkins County is a local jurisdiction not under direct control of the governor. That county jail made its own decision to release Hernandez. When pressed repeatedly to condemn the decision, Hochul ultimately said the individual should have been held and that this is not what the state of New York would have done in a state facility. So, while there was some political deflection, there was also eventual acknowledgement. My take? This reflects a very real and complex structural issue in our federal system. States do not always have authority over counties and cities, especially when it comes to local law enforcement policy. So, pinning the county's decision entirely on the governor oversimplifies the situation. This hearing raises a legitimate policy debate. Should local jurisdictions be required to comply with ICE detainers? Let's be clear, ICE detainers are requests, not legal warrants. Courts have ruled that holding someone solely on an ICE detainer without a judicial warrant can be unconstitutional. That's part of the reason some localities refuse to comply. They're trying to avoid lawsuits or constitutional violations. But in this specific case, there was a federal arrest warrant signed by a judge. That changes the legal picture and undermines the argument for noncompliance. At minimum, holding the suspect for 1 to 2 hours more for ICE to arrive seems like a reasonable ask, especially given the violent charges. If true, the refusal to cooperate here raises serious concerns about public safety versus political signaling. There's a very real difference between protecting undocumented individuals with no criminal history and releasing someone accused of violent, repeat crimes. That distinction seems lost in this debate. Now, a second speaker at the hearing, likely a Democratic representative, used their time to pivot hard in a different direction. They spoke passionately about immigrant communities living in fear, criticized Trump-era policies, and denounced the use of military force on American soil. There's a valid discussion to be had there too, but let's be honest. This hearing became 2 hearings in one. One half was about local noncompliance with federal law, and the other half was a broader indictment of Trump's immigration and foreign policy record. At one point, the speaker likened current U.S. policies to the abuses listed in the Declaration of Independence, warning against authoritarianism and declaring that we have no kings in America. Was it theatrical? Yes. Was it over the top in some parts? Arguably. But it also tapped into real concerns, especially among immigrant communities and civil liberties advocates, about the growing reach of executive power, militarized policing, and states' rights being trampled. 1. The county's decision not to hold Hernandez, despite a federal warrant, is deeply concerning. Whether you're liberal or conservative, we should all agree that individuals accused of repeated violent crimes should be detained until proper transfer to IC occurs, especially with a judge-signed order. 2. Governor Hochul could have taken a firmer stance earlier. Her eventual acknowledgement that Hernandez should have been held was important but delayed. If the state's policy is to cooperate in such cases, it should be unequivocal, even if it involves a local Democrat sheriff. 3. The hearing reflected the hyperpartisan nature of modern oversight. One side focused narrowly on a singular case to attack sanctuary policies. The other tried to shift the debate entirely to Trump's record. Both use emotionally charged language that risks alienating people seeking balanced dialogue. 4. The real solution lies in clarifying jurisdiction and legal authority. Congress should address whether IC detainers need judicial backing to be enforceable and whether localities should be compelled to cooperate in cases involving violent offenders. So, what do you think? Should local counties be forced to cooperate with IC in all criminal cases? Was Governor Hochul's response appropriate, or did she dodge accountability? And how should we draw the line between immigration enforcement and protecting civil liberties? Drop your thoughts in the comments. I'd love to hear from both sides of the aisle. And as always, if you found this breakdown helpful, don't forget to like the video, subscribe to the channel, and hit the bell so you don't miss our next deep dive. Thanks for watching I'm American Interest, and I'll see you next time with more real analysis and fewer sound bites.